Well, hello folks, Bill O'Leary here, coming to you in another video to talk about the topic of a will and when a will can be contested. So before jumping in, quick intro. I'm an estate planning, elder law, and probate attorney in my firm, Legacy Planning Law Group in Jacksonville, Florida. So, when can a will be contested? So there's several different ways that somebody can contest or challenge a will. First of all, if the will was not what's called executed correctly, signed correctly, it has to meet certain what are called legal formalities. And so, for example, it needs to be in writing. An oral will does not cut it in Florida. It needs to be signed. Signed by who? Signed by the person that is doing the will, what we call the testator. It has to be signed not only by the testator, but has to be signed in the presence of two witnesses, And those witnesses need to sign the will in the presence of each other, as well as in the presence of the testator. So basically all three need to be in the same room together. There is some development in having some virtual signing capability, but still best practice, get it signed physically in the same room. So can a will be handwritten? Does it have to be typed up? No, it does not. So a handwritten will can still work as long as it is properly witnessed. So just handwriting out a will and not having the proper witnesses is not going to cut it. It does not need to be notarized. But that said, it is best practice to get it properly witnessed and notarized so that the will can be what's called self-proved. So at someone's death, it could be filed with the court, and the court can accept the will and admit it to probate without having to have the will proved up, meaning bringing the witnesses in to testify under oath. So lack of formalities is one basis to contest. Another is lack of capacity. So someone needs to have the legal, faculties, capability of signing a will. They need to be of sound mind, and they need to understand three things. These are the three things that are looked at. Number one, does the person understand the nature and extent of their property, of their assets, of their estate? Number one. Number two, do they know who the natural objects of their bounty are? If it's family members, family members are natural objects of someone's bounty. Do they know who these people are? And three, do they understand and appreciate the practical effect of the will? What's going to happen by the will that they're putting together? What's going to be the consequence? Who's going to get what, when, and how? So again, if someone is perceived to lack capacity, that might be a basis to contest or challenge the will. Third, insane delusion. So someone is under an insane delusion, which means they don't have the proper capability of signing a will. And I'm going to share a quick case that happened almost 20 years ago now. A woman was in the hospital in severe pain and heavily medicated. She ended up doing a new will the day before she died, and that new will disinherited a long-time caretaker and left everything to several charities. And the caretaker came in and contested the will, saying no, she was under an insane delusion. The deceased physicians testified, and they said, look, she was under this medication, it changed her personality, and they gave the medical opinion that she was under a delusion when she signed the new will. And she was making statements to the effect, oh, the caretaker had abandoned her, which was not true, that the caretaker killed her dog, which was not true. The dog was still alive. So long story short, the court threw out that new will executed the day prior on the basis that she was under an insane delusion. So that might be one basis. Another basis to contest a will, and this happens more often than you think, undue influence, that the person signed the will being subject to the undue influence of somebody else. And there's several factors that the courts here in Florida will look at to determine whether there is undue influence. We like to refer to them as the Carpenter factors. That's based on a case from the early 1970s, the Carpenter case. And so the court will look at factors to determine whether there's undue influence. For example, And by the way, no one factor is determinative, okay? So all the factors are weighed together. Was the person that is alleged to have unduly influenced, were they present when the will was executed? Number one. Or number two, were they present prior to then when the person that did the will, called the testator, when they were talking about the will, when they were discussing it? Well, was that family member present? Did that person, again, the undue influencer, recommend the attorney, bring the attorney to the testator? Did that person have knowledge of the contents of the will, what the will was going to say before it was executed? Did that person give the attorney specific instructions? The will needs to say this, that, and the other. Or did the undue influencer sort of secure the witnesses, line up the witnesses for the will execution? Or maybe are they safe keeping the will? Are they keeping the will to themselves, maybe in a safe somewhere? Are they isolating the testator and sort of convincing the testator to disrespect family members? Is there a mental inequality between the testator and the undue influencer, where the influencer sort of, again, maybe of a higher IQ and able to convince the testator to make changes to a will, as an example? And finally, a factor, is the will that was done, are the terms of the will reasonable? Okay, so again, that's undue influence. Real quick, who can contest the will? Who? Three general categories. One, the beneficiaries under a current will. They may not be happy with what they're getting under that will and thought that they were promised something different. Two, the beneficiaries of a prior will, where there is a newer will that purports to supersede the old will. The beneficiaries under the old will, who may not be included in the new will, can make it a challenge. And three, what are called the intestate heirs. The heirs that would take under the state intestacy law if there was no will. So they might come in, and if they're not included in a will that's presented to the court, if they're not a named beneficiary, they may contest the will, hoping to kick it out. Then we revert to the state law, and they would be included, getting a share of the estate. Finally, if a will is ever contested, it's got to be done in court, and the person that's contesting the will has the burden of proof. They've got to make their case. So if you'd like to know a little bit more about wills and how they can be contested, and maybe how we can help, we'd love to talk to you. So as we do in all of these videos, we invite you to schedule a 15-minute phone call. It's complimentary, called our discovery call. Just click on the link that now appears in this video. It takes you right to our booking calendar. If you've enjoyed this video, do like, better yet, share with your friends. And if you haven't already, subscribe to our YouTube channel. So, Bill O'Leary, I'm going to sign off for now. Go make it a great day and a better world.